Okay, offer of judgment. This is part D of Chapter 7, Resolution of Cases Before Trial, in the California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis. California Code of Civil Procedure calls this Section 998. These are 998 offers. Section 998 is titled Withholding or Augmenting Costs Following Rejection or Acceptance of Offer to Allow Judgment. A. The cost allowed under Sections 1031 or 1032 shall be withheld or augmented as provided in this section, not less than 10 days prior to commencement of trial or arbitration as provided in Section 1281 or 1295 of a dispute to be resolved by arbitration. Any party may serve an offer in writing upon any other party to the action to allow judgment to be taken or an award to be entered in accordance with the terms and conditions stated at that time. The written offer shall include a statement of the offer containing the terms and conditions of the judgment or award, and a provision that allows the accepting party to indicate acceptance of the offer by signing a statement that the offer is accepted. Any acceptance of the offer, whether made on a document containing the offer or on a separate document of acceptance, shall be writing and shall be signed by counsel for the accepting party, or, if not represented by counsel, by an accepting party. 1. If the offer is accepted, the offer with proof of acceptance shall be filed, and the clerk or the court shall enter judgment accordingly. In the case of arbitration, the offer with proof of acceptance shall be filed with the arbitrator or arbitrators, who shall promptly render an award accordingly. 2. If the offer is not accepted prior to trial or arbitration, or within 30 days after it is made, whichever occurs first, it shall be deemed withdrawn and cannot be given in evidence upon trial or arbitration. For purposes of the subdivision, a trial or arbitration shall be deemed to be actually commenced at the beginning of the opening statement of the plaintiff or counsel, and if there is no opening statement, then at the time of the administering of the oath or affirmation of the first witness, or the introduction of any evidence. C1. If an offer made by a defendant is not accepted, and the plaintiff fails to obtain a more favorable judgment or award, the plaintiff shall not recover his or her post-offer costs and shall pay the defendant's costs from the time of the offer. In addition, in any action or proceeding other than an eminent domain action, the court or arbitrator, in its discretion, may require the plaintiff to pay a reasonable sum to cover costs of the services of expert witnesses who are not regular employees of any party, actually incurred and reasonably necessary in either or both preparation for trial or arbitration, or during trial or arbitration of the case by the defendant. 2A. In determining whether the plaintiff obtains a more favorable judgment, the court or arbitrator shall exclude the post-offer costs. It is the intent, this is 2B, it is the intent of the legislature to enact subparagraph A to supersede the holding in Encinitas Plaza Real vs. Knight, no year given, that attorney's fees awarded to the prevailing party were not costs for purposes of the section, but were part of the judgment. D. If an offer made by a plaintiff is not accepted and the defendant fails to obtain a more favorable judgment or award in any action or proceeding other than an eminent domain action, the court or arbitrator, in its discretion, may require the defendant to pay a reasonable sum to cover post-offer costs of the services of expert witnesses who are not regular employees of any party, actually incurred and reasonably necessary in either or both preparation for trial or arbitration, or during trial or arbitration of the case by the plaintiff, in addition to plaintiff's costs. If an offer made by a defendant is not accepted and the plaintiff fails to obtain a more favorable judgment or award, the costs under the section from the time of offer shall be deducted from any damages awarded in favor of the plaintiff. If the costs awarded under this section exceed the amount of damages awarded to the plaintiff, the net amount shall be awarded to the defendant, and judgment or award shall be entered accordingly. F. police officers shall be deemed to be expert witnesses for the purposes of this section. For purposes of this section, plaintiff includes a cross-complainant and defendant includes a cross-defendant. Any judgment or award entered pursuant to this section shall be deemed to be a compromise settlement. This chapter does not apply to either of the following: an offer that is made by a plaintiff in an eminent domain action to an enforcement brought in the name of the people of the state of California by the Attorney General. That might apply in the way that I'm trying to use the 998 offer. Maybe. Attorney General, that is, a district attorney or a city attorney acting as a public prosecutor. Not quite sure. The costs for services of expert witnesses for trial under subdivision C and D shall not exceed those specified in section 68092.5 of the Government Code. This section shall not apply to labor arbitrations filed pursuant to Memorandum of Understanding under Ralph C. Dills Act, Chapter 10.3, commencing in Section 3512 of Division 4 of Title I of the Government Code. Notes and questions regarding offers of judgment, aka 998 offers. 1. Consequences of failure to obtain a more favorable judgment. The purpose of statutory offers to compromise authorized by CCP 998 is to encourage the settlement of lawsuits before trial by penalizing a party who fails to accept a reasonable offer from another party. TM Cobb Co. v. Superior Court of 1984. Effective award of costs and expert witness expenses. The penalty for failing to obtain a judgment more favorable than the unaccepted offer is the withholding or augmenting of allowable costs as specified in Section 998C through E. Costs affected by 998 include those items recoverable pursuant to CCP 1032 and allowable under 1033.5, and therefore include attorney's fees when authorized by contract, statute, or law. CCP Section 1033.5A10, Section 998 also authorized the trial court in its discretion to require the offeree who fails to obtain a more favorable judgment to pay the expenses for certain expert witnesses of the offerer. 998C and D. B. Prejudgment interests. A defendant's rejection of a 998 offer in a personal injury tort action has another consequence if the plaintiff subsequently obtains a more favorable judgment. Pursuant to Civil Code 3291, the judgment shall bear interest of 10% calculated from the date of the plaintiff's first 998 offer and accrue until satisfaction of judgment. See Latkin v. Watkins, Associated Industries of 1993. Civil Code 3291 authorized courts to award prejudgment interest only on damages attributable to personal injury. Corley v. State Farm Mutual Automobile Insurance Co. 1991, prejudgment interest award under Civil Code 3291 held improper where 998 offer rejected by defendant in insurance bad faith action because action was for interference with property rights, not for personal injury damages. Alright, so 2. What constitutes a more favorable judgment? One of the more difficult issues faced by courts applying CCP 998 is determination of whether a party has failed to obtain a more favorable judgment than the pretrial offer. What items should be included or deleted from the the amount of a verdict in making this determination can be quite complicated. And that's all it says. It goes on to A, what court costs added to the verdict. Under the current version of 998, reproduced above, court costs awarded to the prevailing party pursuant to CCP 1032B and 1033.5A are added to the plaintiff's verdict when the 998 offer was made by the plaintiff and rejected by the defendant. Stallman v. Bell, 1991, Hawk v. Allied Signal, 1994. However, when the offer was made by the defendant and rejected by the plaintiff, only the plaintiff's pre-offer costs are added to the verdict. CCP 998C2A. What is the policy reason for this difference in treatment based on who made the offer? B. Are attorney's fees added to the verdict? A more troublesome question had been whether an award of attorney's fees should be added to a verdict when making the 998 favorability determination. In Ensenada's Plaza Real versus Knight, 1989, the court held that an award of attorney's fees pursuant to a contract was not an item of cost within the meaning of existing CCP 1032 and 1033.5A10, and consequently could not be included in determining a more favorable judgment under 998. The soundness of the Ensenada's Plaza holding became doubtful after 1990 amendment to CCP 1033.5A10, which specifically made attorney's fees pursuant by contract, statute of law, or an item of cost recoverable by a prevailing party. Subsequently, a 1987 amendment to 998 superseding the holding of Ensenada's Plaza Real vs. Knight, CCP 998C2. Accordingly, the current version of 998, an award of attorney's fees to the plaintiff as a prevailing party, will be added to the verdict in the same manner as court costs. Okay, that's terrible news. That is terrible news. And it's plainly what I wanted to know. But again, it has to do with the 998 offer, but I was trying to limit that. Okay, maybe I can. C. Recoverability of offer. An unaccepted offer made pursuant to CCP 998 may be revoked by the offeror prior to the expiration of the statutory period. T.M. Cobb Co. v. Superior Court of 1984. However, a 998 offer is not revoked by a counteroffer and may be accepted by offeree during the statutory period unless the offer has been revoked by the offeror. Poster v. Southern California Rapid Transit Dist. 1990. 4, Part 4 of the notes. Offers of judgment in federal court. Rule 68 of the Federal Rules of Civil Procedure authorize an offer of judgment process for federal courts analogous to that of CCP 998. However, under Rule 68, only a party defending against a claim may serve an offer of judgment. So only a defendant may make this offer on the adverse party, and the other remains operative for 10 days. The consequence of rejecting an offer is also more limited than under CCP 998. Rule 68 provides that if the judgment finally obtained by the offeree is not more favorable than the offer, the offeree must pay the costs incurred after making the offer. Okay, so that's what I had in mind. But this is more so all costs. I'm thinking from what I just read in California, that is. So, just that this U.S. Supreme Court construed this language to encompass only a judgment in favor of an offeree and not a judgment against the offeree. Delta Airlines Inc. versus August 1981. Rule 68 is simply inapplicable in a case where the plaintiff offeree lost at trial because the defendant offerer obtained the judgment. Okay, so that's the end of Chapter 7. Chapter 8 will deal with trial and post-trial motions.